Hi, I'm Ralph Losey at the University of Florida 5th Annual eDiscovery Conference. I'm here today with United States Magistrate Judge Gary Jones.
Hey, Ralph.
Judge Jones, this is not your first trip to this conference, so what keeps bringing you back?
Well, it's a great learning experience, and my fifth conference, I learned something new, and I don't mean about the law, but some new tool, some new skill in the area of e-discovery, and I think it makes me more knowledgeable.
Well, we appreciate having your wisdom here and giving us a judicial perspective. You and I were chatting a moment ago about one of the new rules. It's kind of an obscure one. Let's see if I can remember it. Rule 16B3B5. And it's a rule kind of directed to judges on the scheduling order. Would you like to comment on that?
Well, this was added to the rule. It allows for or encourages a pre-conference with the court, with the judge, before a discovery motion is filed. You had asked me if I'm aware of, am I using it, or other judges using it? Generally, I don't think many judges are utilizing it. I know Judge Rosenthal out in Houston is very knowledgeable on the rules. She thinks it's a great tool. I have been involved in cases, usually large cases, big class action or an MDL, where it is effective. And why it's effective, it allows the lawyers to talk to the court off the record. And amazingly, large discovery disputes get much more focused and much more narrow. And then if there is something for the court to resolve, you can go forward and have a hearing. But in most cases, it narrows things down. It moves things along quickly. And I know the judges that have used it think it's a great tool. It's new. It's out of our wheelhouse as judges. But I think it's a great idea, and I'm open to using it if there's the right opportunity.
Now, you may have heard kind of a famous quote from Judge David Waxy. He says that lawyers are like elementary particles. They change when observed by a judge. Ever heard that one? And we all want to cooperate, but I doubt many of the attorneys appear before you and say, no, we don't want to cooperate. What as a judge, you've been doing this a long time, and you're in private practice for a long time too, you know there's some lawyers that are not born cooperators, just doesn't come naturally. What do you do to try and tell the difference about who is and is not cooperating?
Well, I'll make a shout out to the bar. I think since the rules have been amended, I'm seeing a much higher level of cooperation. I think the word is getting out there. There are exceptions. But you are correct, miraculously, when a judge is involved in a discovery dispute, for example, in a pre-conference meeting, everyone seems to get a little more reasonable, because the last thing a lawyer wants to, the look before the judge is to be an unreasonable person. So. I don't know what it is, but it is sort of magic when lawyers appear before a judge. Reasonableness seems to rise to the top.
You see a lot of attorneys, I'm sure different levels of experience appearing before you. What kind of practice pointers or suggestions might you give to an attorney as to how to better present their issues and arguments on e-discovery issues? What advice?
Well, I think probably the one thing I am seeing lacking, and we're going to talk about this on one of the panels on keyword searching, is when there is a dispute, and it's a legitimate area where there can be disputes, a lack of metrics presented to the court, a lack of sampling. Keyword search is a very amorphous concept of how you put together words with connectors to locate documents, but it's all about, are you getting to the documents that are relevant? It's really all about that, and the way for the court to really understand that is through metrics. The number of hits, the type of hits, where the hits are, that educates me. to simply ask me as a judge to help on divining a keyword search term makes no sense. I know nothing about the case, the industry. It's the lawyers and their clients that are going to be most knowledgeable on keyword searches.
And you know what I think about keyword search anyway, don't you? Well, thank you very much, Judge. I appreciate your time and answering our questions.
Thank you, Ralph.